Succession planning is essential to any closely held business. The critical aspect of any viable succession plan is open and honest dialogue between the owners. Once the owners agree upon a succession plan that works with their personal and business goals, that plan should be reflected in a clearly written agreement. If any of the owners are married, their spouses will need to acknowledge and agree upon what happens to the owner's equity if certain events occur. If one or more events do occur, there should be a mechanism where the other owners and then the company have the option to purchase equity that would otherwise transfer to a spouse or other third party at fair market value. Without a clearly written and negotiated agreement, third parties are likely to end up owning and/or controlling the closely held business, which is likely not a workable scenario for the other owners and could eventually result in the business being financially harmed or worse, dissolving. A succession plan should address how an owner's equity should be transferred in certain events. The most common events that a succession plan should address are death, divorce, disability, disagreement, and distress. Upon the death of an owner, the remaining owners likely do not want a surviving spouse or heirs as a co-owner of the business. Without a succession plan, the equity held by the deceased owner will likely pass to someone that has no involvement or interest in the ongoing success of the business. In the event of divorce, the remaining owners are likely not open to having a potentially disgruntled ex-spouse as a co-owner. Both the owners and their spouses should obtain their own legal counsel to advise them concerning the effect of a divorce on the ownership of the company. If an owner becomes disabled and is no longer able to participate in the operation of the business due to illness or other events, or is determined by a physician designated by the business for an agreed upon time, the remaining owners should have the option to purchase the disabled owner's equity at fair market value. It's not fair for the remaining owners to perform the tasks normally handled by the disabled owner and for that disabled owner to continue to share in the success of the business. There should be an agreement in place to address a situation where the owners simply can't agree on how the company should operate. That agreement should have a dispute resolution provision that gives the owners the best chance to reach an agreement and should require that they negotiate in good faith. If the owners are not able to resolve their disagreement, the succession plan can provide a mechanism where the owners agreed to a process to buy out an owner that is not aligned with the other owners. An agreement should be in place in the event one or more owners have financial difficulties and are either voluntarily or involuntarily involved in some form of insolvency proceedings. The other owners will not want a bankruptcy trustee or creditor having a say on how the company operates going forward. Without a succession plan, it's likely that a third party who had nothing to do with the creation and operation of the company will own some of the equity if one or more of the events described in this video occurs during the existence of a closely held company.